PA for General Motors Legal Services webinar. Before I begin today, I would like to tell you about an upcoming webinar we have planned. We are planning a webinar about beneficiaries, what they mean, and how to use them. We will discuss many topics of beneficiary designations, including ladybird deeds, also known as transfer death deeds. Please note that this webinar will be held on Thursday, April 25th. Be on the lookout for additional information on this webinar in the ongoing weeks. Today, we will be talking about Qualified Domestic Relations Orders, or QDROs. We received a number of questions from you, and we hope to answer as many of those as possible. Also, at the end of this webinar, there will be a brief survey. Please take a few minutes to answer this survey. Your feedback is very important to us. We will begin by introducing ourselves.
Linda Carr is a graduate of the University of Michigan and obtained her law degree from Wayne State University School of Law. Linda was an estate and gift tax attorney with the IRS and a judicial attorney for a Wayne County Circuit Court judge prior to joining the former Legal Services Plan. Linda began her tenure with the former UAW LSP as a staff attorney, eventually becoming a managing attorney. Linda practiced and trained other attorneys in the areas of bankruptcy, family law, tax, probate, and real estate. Linda is currently a managing attorney in the New Plans Dearborn, Michigan office, handling family law cases. Welcome, Linda.
Thank you. I would like to introduce you to Marty Quinnan. Marty received his bachelor's degree from the University of Michigan and his law degree from the University of Wayne State University. After a couple of years in private practice, he joined the former UAW Legal Services Plan as a staff attorney. He has practiced in real estate, family law, estate planning, probate, and tax law. Marty is now the managing attorney in the General Grand Rapids office for the new plan. Welcome, Marty.
Thank you.
Now, Marty, I think to really understand why a QDRO might be needed, we first need to talk about the divorce process. Can you tell me how the divorce process impacts on a person's retirement benefit?
Yes, Linda. A divorce not only ends a marriage, but it results in the division of the assets the parties have accumulated during the marriage. These assets include real estate, bank accounts, vehicles, and other personal property, investment accounts, and also retirement benefits. Retirement benefits, often pensions or 401k accounts, are part of the assets to be divided by the divorcing couple.
Okay.
Just as with the house or bank accounts, the divorce judgment should include if and how the retirement benefit will be divided. This division of retirement benefits, of retirement accounts or benefits, requires a qualified domestic relations order, QDRO or QDRO, we'll probably say it all different ways today, to make this division effective.
Okay. Well, Marty, does that mean the spouse automatically gets a part of the worker's pension or 401k?
No, it's not automatic. It just means that it's an asset to be considered along with all of the other assets of the parties. How much or even if a spouse will get part of the spouse's retirement benefit will be impacted by many other things, such as how long did the employee work for the employer who provides the retirement benefits? How long were the parties married? Are the parties working or are they retired? Does the spouse work? Does the spouse have his or her own retirement benefits? Are the parties healthy and their ages? And are they able to support each other on their own? How much do the parties have in total assets? And how are those other assets being divided?
Well, Marty, that sounds like there are a lot of things to be considered.
Yes, and the analysis is specific to each couple's situation. It's specific to your circumstances. It's important to review your particular situation with your attorney. Spouses may have a claim to benefits, including retirement benefits, that accrued during the marriage. But it is possible that the settlement of the distribution of all of your assets in your divorce may include a provision in which your spouse gives up rights to your retirement benefits.
Okay. Well, Marty, does that mean I may be able to get a divorce and my spouse will not get any of my retirement benefits?
That's right. And this is not unusual in cases where both parties are relatively young, or the parties were married for a relatively short period of time, or the parties have been employed for a short period of time and the vested retirement benefit they have is relatively small.
Okay. Well, how would I convince my spouse to give up the right to any of my retirement benefits under those circumstances?
Well, your attorney can help you figure out how much of your retirement benefits your spouse might be entitled to receive. For example, the benefits earned during the 2 or 3 years you were married. If you are not yet retired, the attorney can help you calculate the present value of your pension. If you've just been married for a few years, and the spouse should only be entitled to the benefits earned during the time of the marriage. If you're currently retired and already receiving benefits, this present value calculation can be relatively simple. But if you're far from retirement, your attorney will need to calculate the present value of your pension.
Well, Marty, you mentioned the phrase present value. What does present value mean?
A present value calculation is one that helps determine what the value of the spouse's share is worth today. I'm not talking about what your vested pension benefit is, what your monthly benefit is, but how much is that future monthly benefit worth today? And it can be a complicated formula that includes factors such as your age, your future retirement age, your life expectancy, your hire date, your date of your marriage, and the amount of your vested pension payment if you retired today. And this calculation produces a current value of your pension, which can then be divided by the marital share. And this marital share calculation takes into effect, or factors in how long you were married during your time of employment. And then the final result of a present value calculation in many cases can be far lower than you might expect.
Well, Marty, I have my present value information. How do I use this to get my spouse to give up any claim to my pension?
Well, if you are younger or you have a relatively short work history or marriage, you can use this then relatively low present value amount to trade for something else, some other asset that you own together. For example, relinquishing an asset in real estate, or the other person's pension or 401k, or any other asset that you may not really want. You can trade off the present value of your pension for some other assets. You could also give a cash amount equal to the present value that spouse could then invest and use for their own retirement savings.
Okay. Well, suppose I'm relatively young. I'm 40 years old, okay? Why do I care if my spouse gets my retirement fund 20 years from now?
Well, if you're divorcing now, you will care, because when you do retire 20 years from now, and you have to give someone else you were only married to briefly a share of your pension, that will affect your monthly income. You may also want to get married again, so you will most likely want that spouse to share the retirement benefit with you.
Okay. Well, Marty, what if I've been married for a while and I have been employed for many years and the value of my pension is pretty high? I assume I'll probably have to divide my retirement benefits. So will I need a QDRO? And can you tell me, what is a QDRO?
A QDRO is a court order which grants a person a right to a portion of the retirement benefits his or her former spouse has earned through participation in the employer-sponsored retirement plan. The two most common retirement plans are a pension, and this is a defined benefit plan. That's what we're talking about with a pension, a defined benefit plan, which gives a retiree payment each month after retiring. The other common retirement benefit is a 401k savings type plan. And this is a plan to which often both the employer and the employee have contributed funds during the time of employment. So it's important to know that each pension plan and 401k plan have their own rules concerning benefits and disbursements. It's important to understand your plan and your spouse's plan before agreeing to any specific split of those assets.
Well, Marty, I talked to a lot of people, and they think that the division of their pension was addressed in their judgment of divorce. And boy, are they surprised when I tell them that we need to do a QDRO. They are even more surprised to learn that a QDRO actually is a two-step process and requires two separate approvals. Can you explain to us exactly what that means?
Yes, that's right, Linda. You need a court order setting out how the benefit will be divided. This may be in addition to and separate from your judgment or your decree of divorce. Some employers require this separate order, and that's usually because the judgment itself does not have sufficient detail and is not specific enough to determine exactly how the pension benefits will be divided. So a QDRO is prepared, that can be prepared and should be prepared during the divorce proceedings and entered at the time of the judgment to give those specific details about how the retirement benefit is going to be divided.
Well, often people contact us who were divorced several years ago, many years ago, and a QDRO was never entered. They are now thinking about retiring. Can a QDRO be entered now?
Generally, yes. Federal law does not impose a deadline for the entry of a QDRO. But you should check with your local plan attorney to make sure your state law does not impose any time limits for entering a QDRO. They can usually be filed, however, many years after the divorce. The court's order alone, though, is not qualified and not sufficient for the division of the retirement benefits.
Okay. Well, Marty, is this where the second approval comes in that we referred to earlier today?
That's right. QDRO is the term for the specific domestic relations order that have been accepted by a retirement plan sponsored by an employer. So the second step is that the order must be sent to the retirement plan. The plan has to accept it and deem that it qualifies according to their specific guidelines and requirements. The division of the retirement benefits is not effective until the order is qualified by the employer plan. Many plans have specific requirements and sometimes even particular forms that must be used, and they will not qualify orders that do not meet all of their requirements. It's important to know that just because you have a court order, that QDRO must be on file with the employer retirement plan in order to pay the alternate payees their benefit.
Well, Marty, I think there are some important terms to know when talking about a QDRO. Let's talk about a few of these terms. Can you tell us who is the participant?
The participant is the person who has earned the retirement benefit. The current employee of the company with the retirement plan or the retiree of the company.
Okay. And who was the alternate payee?
The alternate payee is the former spouse and the person who is designated to receive a share of the participant's benefit.
Okay. I think there are some other important terms we need to talk about regarding a QDRO. They are a shared interest and a separate interest. These are two different ways to divide a pension. Let's talk about each one of them. Let's start out with the shared interest. Can you tell us what this means and how does this work in a QDRO?
Yes, generally those are the two ways to divide a pension in a QDRO, a shared interest or a separate interest. In a shared interest division, the alternate payee, the former spouse, simply shares a portion of the participant's monthly benefits when they go into pay status. Generally, under this approach, the alternate payee must wait until the participant actually retires before he or she can commence their portion of the benefits. Each plan may have different requirements on that issue, though. And under this method, the alternate payee's share of the benefits tracks the participant's benefits. These benefits are calculated solely on the participant's age and life expectancy and work history. There can be a cost to this shared division to provide a surviving spouse option for the alternate pay, and that cost is generally starting at about 5% of the vested monthly benefit.
Well, are there any advantages to using the shared interest approach?
Yeah, since it's a shared interest, an advantage of this method is that if the alternate payee dies before the participant, his or her share of the participant's pension payment will revert to the participant. As an example, if John is the participant and upon his divorce from Mary, a QDRO was entered, and which was approved and created a shared interest in his pension in which Mary gets 35% of his monthly benefit. John gets the other 65%. And then Mary dies. Following Mary's death with this shared interest form of division, her 35% will go back to John, and then he will get 100% of his vested benefit.
Okay. Well, then how does a separate interest QDRO work?
A separate interest QDRO is one where the alternate payee share of the benefits is actuarially adjusted or re-annuitized based on his or her own age and life expectancy. In other words, the assigned portion of the benefits is carved out and actuarially adjusted to provide the alternate payee with his or her own separate lifetime annuity based on his or her own life. This means that the benefit is paid directly from to the alternate payee. The participant doesn't have to pay that small fee associated with the survivor benefit in a shared interest pension.
Okay. Well, Marty, is there any downside to using the separate interest approach? And could you give us an example?
Yes, there is a drawback. Should the former spouse die, the participant is not entitled to a reversion then of the alternate payee share. It is lost forever to you once the spouse's benefit goes into payment status. In this case, for example, if John is the participant and upon his divorce from Mary, a QDRO is entered, which gives her 35% of his pension as a separate share, John retires then and gets 65%. Mary gets her 35%, re-annuitized and actuarially adjusted based on her age. And then if Mary dies, her 35% does not go back to John. There's no reversion when the alternate payee dies with a separate share form of pension division.
Well, Marty, is one method better than the other? And how do I choose which method to use?
Well, Linda, it really does depend on your specific circumstances. This is something that you should talk to your plan attorney about because it can be different in each case.
Well, when we're dividing my pension, are there specific things that we need to consider?
Yes, if we're going to divide the pension, we'll have to look at a lot of the things we've already talked about. The years that you've worked during the marriage, the length of your marriage. Were you married the whole time that you worked? Because we don't want to provide a share of the pension that was earned either before the marriage or after the marriage. Are you in pay status? Have you already retired, in other words? Or will you have to wait for 10 or 15 years to get it? Does your spouse have any retirement benefits? What is the relative financial status of each party? And what are the rules of each party's pension or retirement savings plans? Another factor that can be important is the general practice, the legal practice in your area. How are the courts in your area likely to divide the pension? These factors can all help you come up with a fair and reasonable settlement.
Okay. Well, how should my pension be divided into QDRO?
Well, one good rule is to use a percentage of an amount rather than a dollar amount. This makes things easier because if you award a dollar amount, things can change later on. But you have to really consider all of the factors we discussed earlier. Your attorney can review these with you and offer you guidance.
Okay. Well, suppose I'm entitled to other retirement benefits related to my pension, such as the supplemental benefit. until I reach full retirement age. Is my spouse entitled to any of that?
Well, all of these components of a pension should be addressed in the QDRO, if not also in the judgment of divorce. But remember, there are some benefits that you may never actually receive. If your pension plan offers an early retirement supplement, that's usually only payable until you're 62. If you retire after 62, that benefit will never be paid. So you don't want to commit to splitting a benefit with a spouse that you may never receive. This can just cause problems later on.
Well, Marty, what if my monthly benefit payment as a participant increases over the number of years? Does my former spouse also get an increase in her money?
Yes, this is another component of many pensions that should be addressed in a QDRO. Your QDRO could say that your ex-spouse then just gets a share vested as of a particular date, and perhaps the date of entry of your judgment, with no share of any later increases. This means that any future increases would go directly to the participant. These increases are often cost of living increases, or sometimes perhaps later increases that are negotiated and paid to retirees. The QDRO could give a pro rata share of these increases or these supplemental benefits on a pro rata basis. So perhaps if the spouse gets 50% of the vested benefit, the spouse may also get 50% of the later increases.
Well, Marty, once we figured out that we need to divide the pension, and we have to have a QDRO prepared, when do the payments begin?
Most often, the payments begin when the participant begins to receive benefits. However, if your retirement plan permits, the alternate payee might be able to begin receiving benefits when the participant is eligible to retire, even if the participant has not yet retired. Again, each retirement plan has their specific rules and guidelines, and they should be carefully reviewed by your attorney before your QDRO is prepared.
Well, Marty, you've given us a lot of good information. Some of it sounds a little complicated. So can you give us some examples of what a QDRO division might look like in certain situations?
Sure, Linda. Let's look at some examples. Let's take a few different situations here. First, let's say we have a long marriage, long seniority, and retirement very soon. For instance, a 28-year employment period, going to retire at 30 years and 2 more years, and they've been married for 30 years. So they've been married longer than the participant has worked. So 100% of the pension benefit was earned during the marriage. Let's say the spouse has no retirement benefits. In this case, we're looking at a 50-50 split of the pension benefit. For instance, if the monthly benefit is $1,200, John may get $600 then, and his spouse, former spouse, the other $600.
Okay.
Another situation would be where we have a short-term marriage and a short time of employment. Perhaps married, let's say 8 years, or I'm sorry, employed for 8 years, but married for 4 years. He doesn't plan on retiring for 25 more years. So he worked longer than they've been married. He vested a pension benefit for only 50% of what he has vested now was earned during the marriage. Let's say the spouse has a 401k and is employed. In this situation, I think it would be very beneficial to do a present value calculation to see how much that half of that vested benefit is worth 25 years from now. 25 years from now. What is that worth today? We may find that it's not worth that much. So I think we should do a present value calculation in this situation. Another situation would be a case where, let's say he's been employed for 18 years, has 10 more years to work. They've been married 14 years. So 77% of the pension was earned during the marriage. The spouse is currently not employed and has no retirement benefits. In this case, I would want to do a present value calculation also. And maybe there are some other assets, equity and property, or other savings that could be traded off for the spouse's present value interest in the pension. Otherwise, it looks like about 38.5% of that monthly benefit could go to the spouse.
Well, seems to be a lot of possible divisions of the pension. Are there some things we need to always keep in mind when trying to divide the pension?
Yes, it's important when dividing the pension to make sure that the division is based on the current vested value of the pension benefit. We don't want to award an amount that's payable at retirement, or a share of the amount payable at retirement. Your divorce is happening now. It's a division of your assets as of now. Your spouse should be entitled to what is accrued and vested during the marriage. We don't want a QDRO or a division of the pension which awards a share of vested benefits which accrue after your divorce.
Well, Marty, suppose I have a pension, my spouse has a pension, and we've decided that neither one of us are going to get the other's pension. I don't need to get a QDRO, right?
Well, it all depends. If neither of you is receiving your pension yet, you're not retired, you do not need a QDRO if you're not going to take a share of each other's retirement benefits. But you should make sure that your divorce judgment specifies that. Your divorce judgment should clearly state that you're each waiving each other's right in the other's pension. If you're already retired and in payment status at the time of the divorce, then you should check to see if your spouse has a surviving spouse benefit on your pension. Generally, retirement plans have these requirements, these provisions in them, and the spouse is automatically entitled to get a survivor benefit unless it's waived at the time of retirement. So if at the time of retirement you're married and then divorced later, this surviving spouse benefit was most likely elected. And you may need a QDRO in that case, since you're not going to divide the pension, to terminate that surviving spouse benefit. And this can be important too if you remarry, because you'll probably want your new spouse to get the surviving spouse benefit.
All right, well, let's move on to 401ks. Suppose I do not have a pension, nor does my spouse, but we have 401ks. Do we still need a QDRO?
Yes, this division should be addressed in your judgment of divorce. And a QDRO should be prepared for the administrator of the 401k plan. Like pensions, each 401k plan is different, and the plan administrator should be consulted to make sure the QDRO is compliant with their requirements. Unlike a pension, a 401k payout is made shortly after the plan administrator approves the QDRO. You don't have to wait until the parties reach retirement age. Let's take an example for a 401k savings plan. Let's say John has $50,000 in his 401k and Mary has $10,000 in hers. They agree that the 401ks are going to be split 50-50. In this case, we need two QDROs, one for each plan, to give 50% of John's to Mary and then to give 50% of Mary's to John. If we do that, and the value, if the value of the remains the same 25,000 will go to John, and 25,000 of John's was the same of John's will go to Mary, and 50,000 of Mary's will go to John. Sorry, I got mixed up on the numbers here.
Okay, all right. Well, how come we just can't divide up the 401ks ourselves?
Well, this could be a huge mistake, because if you just make a withdrawal from your 401k plan, that can be it is subject to taxes, and if you're under age 59 and a half, subject to a penalty. So if you just make a withdrawal yourself and give it to your former spouse, you will be taxed on the money, and you'll have to pay that 10% early withdrawal penalty.
Well, can you give an example? How does a QDRO help us avoid the tax and penalty?
A withdrawal pursuant to a QDRO is an exception to the tax and penalty provisions. For example, let's say you're 52, so you're under the 59 and a half age, you're not eligible for an early distribution, and you get divorced, and you have $50,000 in your 401k, and you agree to divide this so that your spouse gets 50%. If you withdraw the $25,000 and pay it to your spouse, you will be hit with a penalty in the amount of $2,500, and you'll get taxed on the full $25,000 that you withdrew. But in the same situation, if you have a QDRO, which awards your spouse 50% of your 401k plan, the administrator transfers this $25,000 directly to your spouse. You don't pay tax or penalty.
Well, Marty, I need 2 orders like we did in the pension for 401k division?
Yes, the division of the 401k should be addressed in your judgment of divorce, and then a separate QDRO should be prepared for the administrator of the 401k plan. And again, as I said, like pensions, each 401k plan is different, and the plan administrator should be consulted to make sure that the QDRO is compliant with their requirements.
Well, Marty, how should I divide my 401k? Should I just agree to give a certain dollar amount or a certain percentage?
Well, you could do either, but I think you should use a percentage to divide a 401k because of changes in the market. Because of fluctuations in the stock market and the time it takes to get the QDRO qualified, that if you designate a dollar amount, the amount that this could result in you giving your spouse a larger or smaller share of your 401k plan than what you intended. For example, you and your spouse agree to divide your 401k in half. You have $20,000 in your 401k, and your QDRO says your spouse gets $10,000. However, by the time the QDRO is qualified and accepted by the plan administrator, the stock market has dropped, and you now only have $18,000 in your 401k. Your spouse gets that $10,000, which is not what you intended. That's more than half of your 401k balance. In the same situation, if you had a QDRO which said your spouse gets 50% of the account balance, then with this drop in the stock market down to 18,000, your spouse would just get 9,000 then. And then that would be the half of your 401k plan that you intended.
Well, Marty, what if I'm receiving a part of my spouse's 401k? What should I do with it?
That's a good question. If 401k funds are being transferred to a rollover IRA or perhaps to another 401k account you already own, the QDRO should say that. And this would be a so-called trustee to trustee transfer, and it is not a taxable event for you. But if you just put the money into a regular bank account, you will be taxed. With a QDRO, you would not incur, however, the early withdrawal penalty if you're under 59 and a half, even if you don't roll it over. But if you don't roll it over, you will have to pay income tax on this. And remember, with a QDRO, again, as I said, you do not incur that early withdrawal penalty of 10%, even if you're under 59 and a half.
Well, Marty, you've given us some very valuable information today. Thank you. But we do also have some additional questions from the viewer today. And the first one is a very, very good question. Who is responsible for submitting the QDRO?
Well, that is a good question. If you are the alternate payee, you would want to make sure that the QDRO is submitted to the pension or 401k administrator so that you get your share. If it's not submitted and approved as the alternate payee, you're not going to get a share. If you're the participant, you still want to be the party to take care of this so that you know what to expect when you retire, so that there are no surprises. You have some certainty about what you will get when you do retire. And remember, your UAW FCA 4 GM legal service attorney can help you with drafting and submitting your QDRO.
Well, Marty, does a prenup agreement in which the spouse waives the rights to the pension forego the need for a divorce order?
No, this still should be in your judgment of divorce. If there's a prenup by which your spouse waives a share of your pension, that provision still has to be in the judgment of divorce. Yeah, there's a requirement that the divorce judgments specify what happens to retirement benefits. So it should still be in your judgment, and the judgment should clearly state that there's going to be no division of the pension.
Okay. Well, Marty, how long does my former spouse get half of my pension?
Well, generally for at least as long as you live or as long as you're getting a pension. Some plans then have the survivorship benefits too. So in many cases, the alternate payee could receive a share of your pension for the rest of his or her life.
Well, Marty, can a QDRO stipulate that the spouse receives a portion of the participant's pension before that participant retires?
Maybe that's something that depends entirely on the specific provisions of the pension plan.
All right. Well, Marty, what happens if I've been married twice?
Well, if your first spouse was awarded a share of your pension, that spouse will still get that share even if you remarry. Okay. If you are divorced twice, it is possible to have more than one QDRO giving a share to each former spouse. Also, keep in mind the survivor benefit. If the first spouse already has the survivor benefit, the next spouse, current or former, will not get it.
Well, Marty, what happens when a former spouse has not signed the QDRO and more than 10 years have passed?
Well, if you're wondering if the former spouse has lost rights to your retirement benefits, you should know that in most states, the statute of limitations to enforce a divorce judgment for entry of a QDRO does not apply, so that the former spouse could still enforce the judgment and have a QDRO entered even after 10 years from the divorce judgment. If you're wondering how to get this done, say before you retire, you can have a QDRO document prepared for filing with the court. Your plan attorney can prepare the document, and if the former spouse does not contest the QDRO, the court can enter the order, and the QDRO would be sent on to the retirement plan for approval.
Okay. Now, Marty, is it possible to amend or change a QDRO?
It can be if both former spouses agree and if the plan permits the change. A new order would have to be entered with the court, and then the new QDRO would have to be approved by the plan administrator. You should, again, consult your plan attorney.
Well, Marty, can my spouse receive any of my benefits if he or she files first?
I mean, files the case for divorce first?
Yes.
Yeah, the order of filing for divorce generally has no impact on the division of assets in the divorce, including your pension or 401k. But if your spouse files for divorce, you should call the plan immediately and consult with an attorney.
Well, can my spouse get half of my Social Security?
Your Social Security benefits are separate from your pension. How Social Security affects your benefits, how Social Security affects are counted or divided in the settlement of your divorce depends on many other factors discussed earlier. I would encourage you to consult with a plan attorney again about your specific situation.
And finally, Marty, does the legal services plan cover QDROs?
Absolutely. We can give advice, draft the documents, and help you get the QDRO qualified. Call us and open a case.
Well, thank you. And all out there, remember, the UAW Legal Services Plan, it's your plan. Call to open a case at 800-482-7700. And once again, please take a few minutes to complete the brief survey at the end of this webinar. And thank you once again for your participation.
Thank you very much.